Hi, good evening, and welcome back to Men's Divorce Podcast Live. This month, a panel of Cordell and Cordell employees, some colleagues of mine, we're going to be discussing the third in our series of celebrity divorces and discussing the law and taking some questions from you as how these particular cases have sort of shaped the law and outlined the law as it might apply to you and I. Hi, I'm Rick Julius. I'm a senior litigation partner at Cordell and Cordell. Today, I'm going to be joined by two of my esteemed colleagues from across the firm. First, we have Jessica America, senior litigation attorney in Arizona. Jessica, why don't you introduce yourself for us?
Thank you, Rick. Yeah, as you mentioned, I'm Jessica, and I'm from Arizona. I've been in practice and with the firm for about 6 years, and I'm excited to talk shop today.
And next we have Margaret Chesney, a senior litigation attorney out of our Memphis, Tennessee office. Good evening, Margaret.
Hi, Rick. Thank you. I am in our Tennessee office. I've been practicing law for 23 years, almost 1 year with the firm. I'm licensed in Tennessee and in New York, but I primarily practice in Tennessee.
So I appreciate you kind of leading into our first segue. So I am out of the Pittsburgh, Pennsylvania office. I am licensed only in the state of Pennsylvania. Jessica is licensed only in the state of Arizona. So nothing that we say during this webinar is legal advice. But luckily, the legal advice that we can give you, if you schedule an appointment with Cordell and Cordell, just simply call 866-DADS-LAW or visit cordellcordell.com for scheduling of an initial consultation or to get any legal advice from us. So Cordell and Cordell is the world's largest domestic litigation firm with more than 30 plus years of experience representing men before, during, and after divorce. We are a partner men can count on. Very quickly, we're going to take a quick commercial break. We're going to come back. We're going to go over some facts on things, and then we'll have some questions and some topics for Jessica and Margaret as well. Hi, welcome back. So as we said before the commercial break, the topic today is going to be the Michael Jordan and Juanita Vanoy divorce. So we'll go over some facts associated with that, and then we'll talk about some of the legal issues pertaining to that case and kind of how they apply to you and I today. So one of the questions that we tend to ask ourselves when we look at celebrity divorce in a conversation like this is, why do we care about Michael Jordan? None of us have his wealth, have his fame, have his quote-unquote issues. But the fact of the matter is, when we look at situations like this as legal educators, we love a good fact pattern because it's an awesome way for us to go and look at something that doesn't relate to us as objectively as possible and see how the law applies to that. Because the fact of the matter in all of this is, the laws apply to Michael Jordan just the same as they would to you and I. So, couple of items that we want to kind of go through. Michael Jordan met Juanita Vanoy back in 1985. So Michael was drafted in 1984 by the Chicago Bulls. He was an up-and-coming star when he met Juanita. Juanita had worked various jobs throughout the parties' relationship. They were engaged in 1987. She became pregnant with their first child in 1988. He was born in 1989. Now, an interesting legal fact to Michael Jordan's case is that he was married in September of 89 to Miss Vanoy at 3:30 in the morning in Las Vegas. He was quoted at the time as saying, "If you want to do it, let's do it now. We both had a couple of drinks. We'd been gambling and losing. It was our bachelor night. That's how we got married, at 3:30 in the morning at a wedding chapel in Vegas." So leading up to the marriage between Vanoy and Jordan, they had a brief separation issue surrounding Michael's unavailability or alleged unavailability to Juanita during the pregnancy with their first child. This led both of them to contact attorneys and almost led to a paternity suit being filed against Jordan. Cooler heads prevailed. The parties continued with their relationship and eventually married in 1989. They had two more children, Marcus in 1990 and Jasmine in 1992. So over the years, they admittedly fell apart. Personally, Michael's professional career took off. Michael's royalties, Michael's sponsorships all gained value, all took time away from Michael and the family. And in 2002, Juanita filed for divorce and the parties separated. Now, what happened after the 2002 separation is that the parties decided to reconcile and Juanita withdrew the divorce complaint. Okay. So in 2006, though, they decided it was time for a permanent split. So at the time of the 2002 separation, Michael's estate, or Michael and Juanita's estate, was valued at just under $400 million. In 2006, when they ultimately split, it was reportedly worth about $500 million. At the time of their divorce agreement, okay, they announced their divorce along with the final settlement, where Juanita was paid $168 million in addition to the parties' Chicago estate and $2.1 million in counsel fees. So some of the issues that we're going to discuss today and sort of see what our panelists think is going to start with the idea of prenuptial agreements. So one of the important aspects of a prenuptial agreement is the protection of future wealth. And while this particular prenuptial agreement that was signed by Jordan and Vanoy was not disclosed to the public, and parties did not, or the public did not know the individual agreements of the parties, it's believed that it did not protect the future acquisition of wealth as much as it could have for Michael. So, Margaret, what do you think about prenuptial agreements in circumstances? These folks were both young, both about 25 years old at the time of their marriage. Michael knew he had potential stardom, but he was just a rookie coming into that relationship. What would you say to 25-year-old Michael if he was in your office today?
I would definitely say, I'm glad you're in my office and you're speaking to an attorney, because we need to be talking about how you protect your interests and assets moving forward. It's not going to be surprising to anybody that professional athletes have a higher risk or higher potential for divorce due to the demands of their career, their travel, their training, and all of the things that they're negotiating, in addition to the success that he had as a basketball player, but also negotiating very lucrative business deals, including the Nike shoe deal, other business interests, name, image, likeness type of opportunities, other businesses, real estate holdings, all of that. And so as the person from which this income is being generated, he would want to protect his assets.
So I'm glad you brought up the name, image, and likeness, because that's sort of a hot button topic these days with the Supreme Court ruling allowing college athletes, so even younger athletes, to start controlling their name, image, and likeness. Mm-hmm. So Margaret, in Tennessee, you're an equitable distribution state, correct?
Yes, we are.
Okay. So would name, image, and likeness be considered an asset that would appreciate in value or potentially even be a marital asset under the equitable distribution rules in Tennessee?
It could be, since it's a stream, it's a source or a stream of income, but it's also something that you can list as a separate asset, or the future income could be a separate asset if you address it ahead of time in a prenuptial agreement and protect your interests.
So I know in Pennsylvania, even premarital assets can become a marital asset or partially marital asset if they appreciate in value during the marriage. So you're saying in a prenup, in Tennessee, you can exclude that sort of thing from ever being a marital asset subject to equitable distribution.
I believe that you can, yes.
Okay. Now, Jessica, you live in a community property state. Would something like name, image, and likeness royalties be any different in a prenuptial agreement or in a marital estate in Arizona?
Well, obviously, it would depend on what the prenup had said, right? So if you want to make sure that there's language in your prenup that would protect anything like that, and future interest, should it take off, which is what happened basically in this case. So I think it's important to make sure that that prenup is, obviously as solid as possible, and that's something more Margaret will talk about. But aside from that, in Arizona, everything is divided equally if it's acquired during the marriage, as equally as possible. And in Arizona, we say equal is not always equitable. And so it doesn't necessarily mean that you will get 50-50 down the middle, but that is our standard. And so unless there are facts, situations, circumstances that would allow the court to deviate outside of that equal division of assets acquired during the marriage, including anything that wasn't necessarily thought of or can come out of things like a name or image, then absolutely that would be taken into consideration.
Okay, it's interesting you say that, because in Pennsylvania, an equitable distribution state, we've been often quoted as saying equitable doesn't mean equal. Margaret, do you have anything to add to that from an equitable distribution standpoint?
We definitely always say equitable does not necessarily mean equal, but it means it's discretionary within the court. And so one of the things that a prenuptial agreement helps is to avoid future litigation, because, again, a judge has a discretion, if there is no prenup and you're in an equitable distribution state, to what the judge believes is fair based on the factors in our statute.
And so an interesting point in Pennsylvania law, as I tell clients and potential clients all the time, is when we look at contracts like prenuptial agreements, we tend to have what I call a bigger toolbox than the court may otherwise have. So I'll send this to you, Margaret. Are there other tools? Are there other items that you would suggest a potential client putting into his prenup?
Well, I think clients definitely really need to clearly think about what their intentions are and what they are trying to do. They may be trying to protect interests for children of other relationships. They may be trying to protect real estate holdings. There's so many things that speaking with an attorney and making sure that you put all those things in the agreement and that you're clear about what your intentions are. I think that's the smartest tool in the toolbox, is to have a clear vision of what your purpose is in the prenuptial agreement.
So what I'm hearing you say on that end is, just because you think you have everything buttoned up, you think the law applies in a reasonable manner, doesn't mean that it necessarily does, correct?
Correct.
Okay. Can you give an example of something that might not be able to be in a prenup? If I'm a guy and I say, well, I don't want to pay an attorney, I'm going to go to one of those websites and I'm going to make my own prenup so that I don't have to pay for this one. What are some of the common pitfalls to something like that?
Well, not knowing the things that can and cannot be included in a prenuptial agreement. For example, there's a famous couple that almost got married and had a prenuptial agreement, and the potential husband wanted this was a high asset relationship. He didn't want his potential future wife to gain more than 135 pounds. So he put a clause in there that for each pound over 135 pounds, she would pay him $500,000. That's not a reasonable provision. I mean, I'm not the judge. I don't think that would be an enforceable provision in a prenuptial agreement.
So there's a difference between what can be contracted for versus the idea of what can be enforced in court.
Correct. Also, like custody of future children that have not been born would not be something that would be enforceable in a prenuptial agreement, because judges do always need to approve what happens with the welfare of children and custody of children going forward.
And that would include in Arizona, that would include child support as well. So you can't agree in a prenup that one party will not pay child support or neither party will pay child support. The courts in Arizona wouldn't enforce that later unless they found that a child support award of 0 is in the children's best interest. But it definitely would be looked at and not automatically enforceable.
Well, one of the common problems where folks come in with an already drafted prenup or even an already drafted settlement agreement under Pennsylvania law is this idea of either waiving child support or agreeing to pay some larger amount of child support in exchange for some other asset. And weirdly enough, the courts in Pennsylvania will actually enforce an agreement to pay more support, but they won't enforce an agreement to waive support. So there's certain things that just because you're contracting for these items and you think, well, it's a contract, it has to be enforceable. Yes, it's in the contract, but it's not necessarily enforceable. One of the items that comes to mind in more of a settlement standpoint is this idea that parties can actually exchange assets for a waiver of child support or in exchange for full custody or that sort of thing. And I have guys come into my office all the time that say, well, I signed this contract and I gave her my entire 401k and she said she would never sue me for child support. Well, the problem with that is half of that transaction is technically enforceable under the law, in that the 401k transfer is fully enforceable and the child support waiver is fully unenforceable. So then we have a major uphill battle to climb. So it's just another reason why you really need to contact an attorney out ahead of even your marriage, but certainly let alone any settlement pursuant to a divorce action. So again, we invite you to visit CordellCordell.com or call 1-866-DADS-LAW in order to schedule a consultation. We'll go over all of that with you, see how we can help you out. So I'm going to move on to another topic that we mentioned in the fact scenario, and that is the initial split between Michael and Juanita back in 2002. So at that point in time, they did Juanita filed for divorce. They did separate, but somewhere thereafter, they decided they were going to give it another try. Now, it didn't last, and in 2006, they separated for good. And during that period of time, it's reported that their marital estate had appreciated by approximately $100 million. Now, Jessica, do you have any advice for potential clients on the idea of reconciliation and maybe setting terms for that sort of thing?
Yeah, I mean, in fact, Margaret and I spoke about this before. She had some really good points. But in Arizona, we have a whole system. You can file a petition for reconciliation services. They basically put your case on hold for 60 days to allow time, if one party believes that there is a chance reconciliation is possible. In Jordan's case, who knows? But at that point, if someone had actually filed for divorce, there is that wait period that you can file for. Basically, if you're not ready, or you think that there's some agreements or something that you two can come to without court intervention, those sort of things. So that's available at least in Arizona. But I know Margaret had some other points on that issue.
Margaret, what do you think?
Well, I mean, this is when you really need to speak to an attorney, because it depends on the state that you're in as to when the court may value the assets of the divorce. In Tennessee, we value assets as close to the actual date of divorce as possible. But in other states, like, for example, New York, they value them at the date of the separation or when the complaint is filed. So once a complaint is filed, it sort of puts a freeze for future asset growth that could have benefited Michael Jordan had he, chosen to get a divorce at that point in time, but had consulted an attorney and moved forward instead of waiting.
Yeah, and I had thought too, at least by back then, if they had filed maybe a legal separation, that's what we probably would have advised, because what that would do, it would sever the community. So anything that was acquired thereafter, the legal separation is basically like a divorce, except you're still married. So if they were considering reconciling, then they didn't have to get divorced. But maybe, especially with this amount of assets, a legal separation could protect you from what happened in this case.
Yeah, it's an interesting point, Jessica, because in Pennsylvania, as an equitable distribution state, we don't actually have a legal separation filing. So we use a completely different standard as a separation is concerned for valuation of a marital estate. It's valued, it's identified as a snapshot at the end of the separation, which is defined as when they quote unquote stop living as husband and wife or stop living as a married couple, but there's no actual filing for the separation itself. So that snapshot in 2002 could have very well been $100,000 or $100 million less for Michael had he remained separated. But another nuance of Pennsylvania law is that reconciliation, albeit brief, actually restarts the separation clock and basically cancels out that entire 4-year period as if they were married the entire time.
Yeah, that is a good reason why you should contact your local Cordell office, because it does not work like that out here. Unfortunately, I have clients who've been living separate and apart for years, and that's a big question. Why would she be entitled to anything that I acquired, this 401k that I've been building for the last 4 years? We haven't even been living together. I don't know what she has. She doesn't know what I have. And all of it would be considered community, meaning she has an interest in half of anything he has and everything she has. And that's really upsetting for some clients. So definitely reach out. The sooner, the better, just to get some consultation on these type of issues.
Yeah, I think that goes back to the overall theme is you want to make sure you understand the law. And the law doesn't always apply as reasonably and rationally as a reasonable, rational person might think. So if there's any question whatsoever, obviously we caution against, Googling it and going through and trying to find the answer yourself when it's as simple as a phone call away for our purposes. So I'm going to move on to the next topic here, and that has to do with Juanita's support of the family during Michael's career. Obviously, we know a professional athlete is away from the family for a lengthy period of time. The NBA season is basically half a year long, travel, practice, working out year round. So as we understand it, Juanita, worked very little or worked sort of part-time, bouncing around from job to job, but her primary role was supporting the family and the 3 kids. So what role, Jessica, does that play in the idea of distribution, maintenance, et cetera, in divorce?
Sure. Yeah. It plays a huge role. As many of those who are listening and will listen in the future will come to find out, in most states, those sort of facts are very relevant. And unfortunately, if you're on, the side of the person who's working during the marriage, will have to split, at least in Arizona, everything that you have, and then most likely be responsible for spousal maintenance and potentially child support if there are children involved. So recently, Arizona came up with a calculator that they've implemented. Over the last couple of years, they've been testing it out, and now it is fully enforceable, where similar to child support, we would plug in your income, her income. If she doesn't have any income, it would be 0. And then how many children you have, how long you've been married, and it comes up with a formula, gives us a guideline. So it's a range. There's a low, a medium, and a high support amount. And then similar with duration, it's a range. So between this many years and this many years, and the courts have to stay within those guidelines unless there's extenuating circumstances or reasons that they should deviate around it. But unfortunately, there has not been a case yet where we've been able to completely ignore these guidelines in most cases.
Margaret, what's the support system in Tennessee like?
Tennessee has 4 different forms of alimony and factors that the court would consider in awarding alimony. There are instances where if someone receives enough of the division of the marital estate that they would not necessarily have to pay alimony. It's certainly not mandatory, but that would be an issue that would be litigated unless it's addressed and resolved in a prenuptial agreement.
So why don't we take a look at, let's say, a family like the Jordans, who have all of this money and all of this wealth and all of this fame, and looking at what their budget was and how much they spend and what their standard of living is. Jessica, does that come into play in an item like alimony or spousal maintenance in Arizona?
Absolutely. And I haven't had a case like Jordan's lately with all this money and assets. But in similar cases where you have a business, let's say, and the business is valued at over $1 million, that's a big asset that is divided ultimately. And then there's houses and property and things. Ultimately, we have seen success in dividing property and assets to where the other party has enough to support herself. Maybe she has a home that's free and clear, so she doesn't have very many expenses. So once the court determines the person is entitled to spousal maintenance, they then can go through different factors to determine whether they should be awarded it. So when I mentioned earlier we have a calculator, those are the guidelines. But if there are circumstances where the party lacks sufficient property without the marital assets, but now has all this property, then the court can absolutely take that into consideration.
So let's assume hypothetically in 2002, maybe Michael had a lesser confidence in the reconciliation. If he would have started paying off, marital residences and trimming back the budget from 2002 to 2006, maybe he would have had less of a cash outlay in the settlement in 2006.
Yeah, absolutely. I think that it's important, though, that if you have that much cash and it's being divided, we use those facts to show that she now has a retirement account with this amount in it. She now has a bank account with this amount in it. She now has a home, with no mortgage or a very low mortgage. And so those are all factors that we would use to support our request that the court deviate outside the guidelines in setting spousal.
So with just a few minutes left in our episode today, do you have any advice on how Michael could have done things differently or gotten a better result than the $168 million a house and $2.1 million in counsel fees he had to pay in this settlement? Margaret, I'll turn to you first.
All right. Well, I'm not sure that he might have done better or worse. I don't know. But lesser known agreements are postnuptial agreements, reconciliation agreements. I think we touched on legal separation agreements. There are many stops along the way where if Michael had gone to an attorney and spoken to that attorney about my circumstances have changed, our assets are more, my income is greater, whatever it is, there are ways to do agreements along the way that can address some of these issues so that you lower the risk of litigation and have more control over what's going to happen with those assets.
Jessica, how about you? Any suggestions for Michael on how he could have done things differently?
I agree. I don't know that it could have gotten better. I think that ultimately he ended up okay, despite the fact that it was one of the largest settlements in history. I think he did all right considering. But I would say the same thing as well as the legal separation order, potentially meeting with your CPA or an estate's probate attorney to discuss a living trust that you can move some of those assets in. If you are separating and you're not sure what's going to happen next, even coming to agreements with her, like you can have this house, I'll have this house, and signing over rights, disclaimer deeds, quit claim deeds, so that all of that is already done in the event that it doesn't work out. So those are some things. And then also making sure that your business income is completely separate than your personal income, because when it comes to dividing things, it needs to be a clear line in order to protect each of those interests.
So you're saying when it comes to prenups, you can't always cut corners. They really have to be as ironclad and tightened up as possible.
That's right.
So I do have some good news. Michael's remarried, and by the sounds of it, his prenup with his current wife has been very public, and that he decided and his attorneys negotiated for him a prenuptial agreement that is reportedly only valued based upon the length of the marriage, with a hard and fast number of $1 million per year of marriage in the event that either one of them decides to get divorced. So I'm glad he learned his lesson the second time and got everything buttoned up. And I wish him and his new wife the best of luck. So we're going to wrap up now. I really appreciate everyone joining us today. Certainly thank you to Jessica and to Margaret for joining us today. As I said at the beginning, please visit us at CordellCordell.com or give us a call at 866-DADS-LAW. We're happy to discuss the specifics of your case and see if there's any way we can help you out. If you're looking for more content, please subscribe to our YouTube channel or further Men's Divorce Podcast or Men's Divorce Podcast Live airs. Our live webinar today is presented by Lexicon, a legal technology company. We thank you for your time, and please contact us as soon as you can.